G'day Year 11, so I just wanted to go through the material that we've got for your exam. I'm going to do this by going through sector and just looking at the notes, one set of notes at a time, just to make sure that you can see where we've covered all the topics. I feel like if you can engage with what I'm saying, if you're comfortable with the content, then you've got yourself to at least a C standard. Remember, those who want to do better than that have got to go beyond just this basic content. So let's wander through and have a look at the notes as they appear week by week. So the first one we've got there are the characteristics of a good law, and this is going to be important. We've done exercises where we've compared a law against these characteristics. Or the features of a good law. The first is it has to balance individual rights with community good. So, for example, we could solve some of the alcohol-related violence problems perhaps by banning alcohol completely. That might be good for the community, but does it allow individuals to have a choice that they're probably entitled to as adults? So that's the first thing. Does it balance individual rights with community goods? The law should be clear. Plain English is a useful benchmark to think about. Is it spoken enough or to communicate enough in plain English that everyone can understand it? It should be stable. We don't want laws to be changing rapidly too often. It's one of the reasons also why we don't backdate laws or make them retrospective. We have to have confidence that the law is stable and isn't going to change on us without us being aware of it. The law should apply equally to all. So one area of the law that's an interesting one is that politicians speaking in Parliament are allowed to say whatever they want under this idea of parliamentary privilege. So they can't be sued, for example, for what they say in Parliament. The question is, does that favour one group of people? So it should be applied as much as possible to everyone, and it should be capable of being enforced. If you ever had a law, for example, that people shouldn't think about terrorist activities, well, that's going to be very hard, because how do we know what anyone's thinking at any one time? Now I'll just scroll down and check there's nothing more there. Okay, the next couple there are very important topics. The court hierarchy. If we just have a look at that. We've got 3 courts in the Queensland system, and 3 core courts, the Magistrates Court, the District Courts and the Supreme Court. They hear both civil and criminal cases. If we look at each of those courts individually. So Magistrate Courts deals with less serious offences, and civil cases where the amount disputed is up to $150,000. Important thing to keep in mind here is there's no jury for criminal matters. It's just the magistrate who makes the decision in that court. The District Court, cases with a maximum penalty up to 20 years. They also hear appeals from cases from the Magistrates Court. So this is called the appellate jurisdiction. And civil disputes involving amounts between $150,000 and $750,000. Occasionally a jury is used. We then go to the Supreme Court, the highest court in Queensland. It also includes the Court of Appeal. So it hears the most serious criminal and civil matters. The Court of Appeal, which is a panel of 3 to 5 Supreme Court judges, hears appeals from both the Supreme Court and the District Court. The next area is the Constitution. I'll just, as this is coming up, just remind you that when we're talking about the decision made by judges in civil matters, they often become part of what we describe as common law. The Constitution is about the functioning of Parliament, which is more related to statute law. The Constitution. This is the document that sets up the structure of Australian Parliament and laws. Okay, within the Constitution, it talks about the separation of powers. So the separation of powers refers to three different processes: the making of the law, which they say the Parliament should be involved in; the implementing of the law, which they say the executives or the ministers should be involved in; and the interpreting of the law, which is the judges. There is some overlap because the ministers are also members of Parliament. The idea is that they should be separate so that no one gets too much power. And as I said, set out in the Constitution, which is the primary piece of legislation that gives governments their authority and also limits what they can do. Divides powers between the Commonwealth and the states. And importantly, if there's an area where the two laws, the state and Commonwealth law, are inconsistent, the Commonwealth law prevails. Three different sorts of powers. The first is exclusive. They're the powers that can be exercised by the Commonwealth, including making money and having an army. Then you have the residual powers. They're the powers that are exercised by a state, for example, having a police force. And the third is the concurrent powers, which is where both the Commonwealth and states can make a law, but Section 109 of the Constitution says that when the law of the state is inconsistent with the law of the Commonwealth, it's the Commonwealth, so the federal government, the Parliament in Canberra, the Australian Parliament, that shall prevail. And it's not easy to change the Constitution. You need a majority of voters in a majority of states. And the double majority is what's often referred to. Okay, the next topic we looked at many discussion work that week. The doctrine of judicial precedent, which is a really important topic. Now, this is all about common law. So common law is what we see in is judge-made law. Law that comes from the decision of previous judges. So judges are obliged to follow the decisions of earlier cases in equal or higher courts when the facts are essentially the same. It follows a pattern of behaviour, right? So that there's a precedent, something's gone before that set a standard. And this is, the primary purpose is about consistency. We look at the court hierarchy. Here we've included the High Court of Australia because cases can go there, and certainly the Baden-Clay case at the moment, and I think also the Daniel Morecambe case is being, appeals have been made to the High Court. So it is part of the Queensland structure even though it's outside of Queensland. Previously there was the Privy Council in England, but that's no longer part of the court structure. When you talk about the cases that a court hears, there's both the original cases and the appeals cases, original jurisdiction and appellate jurisdiction. And in the judgment we have to understand two elements. What's the ratio, the main reason for the decision, and the obiter dicta, the opinion that might be expressed in their decision. And there are examples of that in the textbook that's important to be aware of. Next we look at Parliament and the law. Now we're going back to statute law, law made by acts of Parliament. In the federal Parliament, the Parliament in Canberra, the Australian Parliament, where Malcolm Turnbull is Prime Minister and Bill Shorten is Leader of the Opposition, there are two houses of Parliament, the lower house and the upper house, known as the House of Representatives and the Senate. So when a law is passed through the Parliament, it starts as a proposed law, a bill, voted on by the House of Representatives, then by the Senate, and if it's successfully voted, it keeps moving through the system, and then signed into law by the Governor-General, the royal assent, and becomes an act of Parliament. So it starts as a bill and becomes an act. The Prime Minister has the most votes in the House of Representatives. That is currently Malcolm Turnbull. In Queensland we have a slightly different structure, 89 seats, and we only have the one House of Parliament. We don't have an upper house or a Senate style House of Parliament. So you have to get 45 seats to hold power. What's interesting at the moment is neither the Liberal National Party or the Labor Party in Queensland have 45 seats. So even now, even though Labor won 44 at the last election, they've lost 2 members. So they're down to 42. So they require some of the independents to support them to be in government. And in 1922, it voted to abolish the upper house of the Queensland Parliament and just having the one house. We now just talk quickly about the different parties in legal disputes. So if you're going to go to court, who might we expect to see there? From a criminal matter, we talk about the defendant, the person who's accused of the crime, and the prosecution, the person who's seeking to prove that that person accused of the crime is guilty. Civil matters, we have a plaintiff, the person who brings the complaint, and the respondent against who the complaint is made. And in appeals matter, we have this word with appeals. We talk about appellant jurisdiction, and appellant is the person who brings the appeal. So if you can link that word to the idea of an appeals, I think that'll help you remember. Importantly, in a criminal matter, the prosecution has to prove a case beyond reasonable doubt. In a civil, it's on the balance of probabilities. And remember that one of the key questions that we often come across is what's the difference between a criminal and civil court? So here's one of them. Another might be that in a criminal matter, you generally have a jury that hears it. The penalties are different. So in a criminal matter, you're talking about someone going to jail or getting a fine, maybe a community service order. In a civil matter, generally it's looking for a sum of money. Now, we've got a textbook reading there on Terra Nullius, and that's an important concept to understand. The reason this is important because it has to do with the arrival of British settlement. And at that arrival, they declared that Australia was Terra Nullius, okay, considered to be an empty land. The explanation there is that the British considered the Aboriginal society to be so primitive that they weren't capable of land ownership. Now that's been challenged since, but this was the idea. It was an empty land, a vacant land, and therefore British laws would be instituted in Australia, which is what happened. And we can see that even the Privy Council up into the 1980s being part of the Australian legal system. So that's why it was important. We got a lot of our laws from England because it was declared Terra Nullius, a vacant land on British settlement. As I said before, that thinking has been overturned. One other element that's worth just talking about with regard to what you need to understand is this idea of stakeholders. It's one of the criteria. So I just want to encourage you to think about the fact that stakeholders are any people who have a interest in a situation. So if you're thinking about a situation from stakeholder perspectives, think about all the different people who can be affected. How are the community affected? How's the legal profession? How's the victim of a crime? If you're looking at a crime, how's both the victim and the perpetrator of the crime affected by something? So that's just something to keep in mind. I just want to go back and see if there's anything else that we want to go over at this stage. If we go back to week 5, there are 2 things I think here that are worth just pointing out. One is have a look at the practice question that I've talked about there. Or the revision question. I think the key thing I want to be thinking about with revision questions though too is how would you compare any law, and we've done this a couple of times, against the characteristics of a good law. Last thing I want to look at is this slide on alternate dispute resolutions. So we're going beyond just the court system. Okay, and we talk about the fact that we can have courts and tribunals and the difference there. Right? Courts are a far more formal process, tribunals less formal. Courts have legal representation, tribunals not so. So stricter rules of evidence, more relaxed rules in a tribunal. So have a look at that. There are a couple of specific things talking about what happens if you don't agree with the government decision, so there's a tribunal role there. But we then get onto the Murray Court, which is a special Queensland court that only deals with the sentencing of Indigenous offenders who plead guilty. And that's because of the high rate of Indigenous offenders who are in jail.